5 words, and I've seen them lose cases. Not because the facts were bad, not because the law was unclear, but because those 5 words gave jurors permission to just walk away. If you've ever said this in an opening statement or heard it said, this video will show you why it's dangerous, what jurors actually hear when you say it, and the exact language to use instead. I've been a trial attorney for over 20 years, taken more than 40 trials to verdict, and collected millions of dollars from my clients. And I can tell you, the cases I've watched slip away weren't all lost on the evidence. One sentence, sometimes just a few words, and you can feel the room shift. The defense relaxes, the jurors lean back, and the plaintiff's lawyer doesn't even realize what just happened. And that sentence is, "This was just an accident." But it's not alone. It travels with its cousins. Mistakes happen. Nobody intended for this to occur. This was an unfortunate situation. If you said any of these to a jury, you're not alone. In fact, most plaintiff's lawyers do it. I used to do it before I realized how much it hurt my case. But you need to stop, because every one of them makes the defense's closing argument before you've even finished your opening. Before I tell you what to say instead, you need to understand why this sentence is so tempting, because if you don't know the trap, you'll walk right back into it in a different form. Plaintiff lawyers say this because they're scared. Scared of looking too aggressive, scared jurors will think they're money hungry or unreasonable, so they soften it. They apologize for their own case before the defense even makes theirs. But here's what they don't realize. When you call it just an accident, you don't sound fair or reasonable. You sound like you don't believe your own case. And jurors can feel that immediately. Here's where it gets worse, because lawyers and jurors aren't even speaking the same language. And I'm going to show you the exact translation happening in the jurors' heads, the one that destroys your case before you finish your opening. Lawyers hear the word accident as a legal description. Jurors hear it as a conclusion of responsibility. When jurors hear "this was just an accident," they translate it to "nobody's really at fault. This could happen to anyone. Why are we even here?" Because in normal human language, an accident is something you don't punish. Heck, even my 4-year-old knows that telling us something's an accident means it's not his fault. If a glass slips out of your hand and breaks, that's an accident. If a storm knocks over a tree, that's an accident. But negligence cases aren't about random bad luck. They're about avoidable harm. And that word accident erases avoidability. It subconsciously tells jurors this was nobody's fault, which is the opposite of what you're there to prove. Let me give you a real example from a trial I watched. Car crash case, defendant ran a red light, clear liability. But in opening, the plaintiff's attorney said, "This was a terrible accident that changed my client's life." Defense didn't have to say a word. The plaintiff called it an accident. The defense took that and made it relatable, made it human, made it forgivable. Game over. The jury didn't hold the defendant accountable because the plaintiff's own lawyer told them they didn't have to by calling it an accident. And even if you don't lose outright on something like this, the verdict is going to be substantially lower if the jury sees it as just an accident. And if that wasn't bad enough, here's the part that should make you really angry. Once you call it an accident, the defense never has to prove anything. They just quote you. In their opening, they'll say something like, "Even the plaintiff agrees this was an accident." In closing, they'll say, "This case was never about wrongdoing. It was about bad luck, an accident. The plaintiff's own attorney even said so." You just saved them from having to really defend anything. Defense lawyers love when plaintiffs soften their own story because it lets the jurors emotionally walk away without guilt for a defense verdict or a low award. You're giving them an easy exit. And look, I've made this mistake. Even though I thought I was being balanced, reasonable, fair, I watched 2 jurors in the front row physically lean back, arms crossed. One of them looked at her watch. I felt the room go cold. We actually won that case, but we got a low verdict and left money on the table. I'm convinced of it. Because I gave the jury permission to minimize what happened before they even saw the evidence. And that's when I learned you can be fair and still hold people accountable. You have to choose your words like they matter, because they do. Okay, so if you can't call it an accident, what do you say? I'm going to give you 4 replacement phrases that keep jurors emotionally locked in without making you sound like the villain. But first you need to understand one thing about negligence. Holding someone accountable does not mean calling them a villain. Negligence requires a rule, a choice, and a failure to act reasonably. Jurors are perfectly capable of saying, "You didn't mean harm, and you still caused it." But they won't say that if you give them permission not to. So here's a way to stop framing cases as accidents and start framing them as preventable events. I'm going to give you 4 phrases. Phrase 1, this didn't have to happen. This kills the inevitability defense. When you say this didn't have to happen, you're telling jurors there was another path and the defendant chose not to take it. It invites the question, well, why did this happen then? And that's the question you want jurors asking. The second phrase is, this was preventable. It implies someone could have prevented it and didn't. Preventable is the opposite of accident. An accident is something no one could stop. A preventable harm is the result of a choice someone made. It's a massive shift in perspective. The third phrase, safety rules exist for a reason and they were ignored. This anchors accountability to an external standard. You're not saying the defendant is a bad person. You're saying there was a rule that exists to protect people and they disregarded it. Jurors don't have to hate the defendant. They just have to agree that the rule matters. And the last one, this happened because of a choice. This works because it puts the spotlight on human agency. Accidents are passive. Choices are active. When you frame harm as the result of a choice, you're letting the jurors focus on the person that had control and did the wrong thing. That's what negligence actually is. Those 4 phrases do something critical. They keep the case human, but accountable. They allow the jurors to say, I understand how this happened, and it still shouldn't have. That's the sweet spot where you want them. Now let me show you how to eradicate these phrases from the entire trial. Because this sentence sneaks in everywhere, and you need to kill it everywhere it appears. In your client prep, ban the word accident. Train your client to say crash or incident or collision. If your client calls it an accident on the stand, the defense will jump right on that and certainly repeat it in closing. In your opening statement, never normalize the harm before jurors feel the responsibility. Your job first is to make jurors care that something went wrong, and if you soften it too early, they won't care. During voir dire, include questions like, do you believe that safety rules exist for a reason? If the judge lets you use that question, that will really build your case. When you question witnesses, stop asking, well, what happened next? Instead, ask, what choice did the defendant make at that point? Choices imply agency. What happened implies randomness. Defense lawyers win when cases feel normal. Plaintiffs win when jurors see that a line was crossed. The language you use draws that line. So the next time you're preparing an opening, prepping a witness, or coaching a client, listen closely for the sentence that sounds reasonable but secretly weakens everything. Because in civil cases, words don't describe the case. They decide it. So comment below. Let me know what softening language you catch yourself using most of the time and see if you get some better options in the replies. If you want me to personally audit your opening for language that's weakening your case, I do limited one-on-one coaching. The link is in the description below. But now that you've gotten rid of those 5 deadly words, there are 3 more that might be doing just as much harm. So I want you to watch this next video to find out what they are.